Let's consider the background to data protection regulation and explain why it is necessary. I'll introduce key data protection concerns, outline the purpose of the GDPR, and explain how it operates. We'll consider key changes from earlier data protection regulation. The GDPR's headline features will be outlined. So, why is data protection regulation necessary? Well, since the 1980s, computers have increasingly been used to store personal information, especially personal information about customers and staff. Usually, this personal information is stored in computer databases. Common examples of personal information include names, addresses, contact details, employment history, medical information, and financial information. Databases make it easy to access, search, and edit personal information. Networked computers and internet connectivity make sharing personal information relatively straightforward. As more organizations adopted computer-based systems to store personal information, the risks and dangers to our personal information getting into the wrong hands have steadily yet dramatically increased. So what are the key data protection concerns? Well, key concerns include: who's got access to this personal information? How accurate is the personal information? And can our personal information be stored without an individual's knowledge or permission? What's the GDPR's purpose? The GDPR aims to streamline, update, and simplify the inconsistent data protection laws of each EU member state. The EU wanted to 1. Give citizens back control of their personal data. 2. Simplify the regulatory environment across the EU. And 3. Provide a level playing field for businesses in the EU. So how does the GDPR work? The GDPR consists of 173 recitals and 99 articles. Recitals set out the reasons for and what the regulation is trying to achieve. Articles spell out the regulatory requirements, that is, the rules. Essentially, the GDPR establishes a set of rules companies and organizations processing personal data must follow. Each EU member state has a supervisory authority responsible for enforcing those rules. In the UK, this is the Information Commissioner's Office, the ICO. In France, it's the CNIL. In Germany, it's the BFDI. The GDPR hasn't suddenly appeared out of nowhere. It's built on the foundations of earlier data protection regulation. For example, if a UK organisation already complies with the DPA, then attaining GDPR compliance will seem an evolutionary rather than a revolutionary step. Many of the definitions and data protection principles in the GDPR are very similar to those of earlier data protection regulation. There are, however, a few notable changes. For example, enhanced privacy notices. The amount of information an organisation must now provide to an individual has greatly increased. The time allowed to respond to information requests has reduced. Under the DPA, information requests had to be responded to within 40 days. Now, under the GDPR, this period is reduced to 1 month, although for complex cases it can be extended by a further 2 months. Unlike the DPA, in normal circumstances, a fee can't be charged. So, organisations are likely to receive many more subject access requests. Other notable changes include the personal data breach notification requirement. In certain prescribed circumstances, a data controller must inform the supervisory authority of a personal data breach. And where there is a high risk to people's rights and freedoms, the people affected must be notified directly. Under the GDPR, the definition of personal data has widened considerably. This now includes online identifiers such as IP addresses, cookies, and location information, plus biometric and genetic information. Let's consider the GDPR's headline features. Organisations must now notify the supervisory authority of significant personal data breaches. Supervisory authority must be notified within 72 hours of an organisation's data controller becoming aware of the personal data breach. This is a major change from prior regulation. The right to be forgotten. People now have the right to ask to be forgotten. Plus, there are additional sanctions, enforcement actions, and hugely increased penalties. Failure to comply in the most serious circumstances can result in fines of up to 4% of global annual turnover, or up to €20 million, whichever is the greater.